Yes, admission would have conflict. Yes,
Pardon to my mention rights. Item 34th and 26th in the list of laws. It may be taken up as last item with the license. Interim bail has been sought and instructions were sought from interim bail.
See that. Please, can I go in, please?
Lordship for fix that MCL matter.
Item number 37.
37 at 10:30. So, but the question is two issues. That it's a latest patent.
Which item you are talking about?
That's 37.
37.
The land pillar has been acquired.
If you have fixed it, we can take up. What is the problem?
No issue. No issue. But on the side. Oh, I see. You could come to the front. My line will go.
So please begin. If you have fixed and
Right.
Now, really see the limited prayer which has been sought is squashing of a particular letter.
No, actually, appellate, I think you are for the appellate.
No, yes, we are seeking for vacation actually.
No, I don't know. I thought I am for the appellate.
No, you are seeking for vacation.
There is an, yes.
There is an interim order.
There is an interim order. But we have filed an application for vacation of the interim order. But for two reasons. It's a,
what is the IN number?
this latest patent appeal itself is not maintainable. Because they have traveled beyond the scope of the pleadings and the prayer in the writ petition. And the Honorable Single Judge Millard has given categorical finding on each of the prayers of the petitioner.
No, I think, we had, I think it is the understanding that we can take up this matter finally today and can dispute it for each question.
But why unnecessary? Same amount of time we have to spend.
Please begin. Please begin, Mr. Mishra, please. Yes.
But I'll just take care of just a few provisions of the scheme that is there.
Which order, Mr. Mishra, is under challenge here?
Before I begin, let me clarify one thing. They have filed an affidavit on Monday containing 102 pages, 10 pages, 50 pages, 150 pages. Monday they have filed it. Copy was served. I immediately sent it to the persons actually who were affected. And they came on Wednesday. We prepared the reply. Today we are filing it. So they cannot take advantage of that affidavit.
Please have a copy then, the other side.
In course of the day, we will file it. But they have filed on Monday.
But
I don't know whether it
can
is.
we finally adjudicate the matter? You have some.
They could not have filed on Monday with this voluminous document.
We have
That's a compilation of whatever affidavits are on record.
we have
It
fixed
is a
this case
compilation.
specifically to today at 10:30.
Then ignore that.
Compilation of convenience.
Ignore that convenience volume and proceed with the matter. Ignore that what you have filed.
Because once you have filed and they are filing the reply, how can we ignore it?
It's a compilation. It's not an affidavit.
No, you do not know that has been not received by you. How
It
you?
come, I don't know whether it has come on record.
Which one?
If something is new, let him point out there is no issue. But we have not brought anything new on record. Whatever already it is on record, that is there. That's all.
Just a minute. Just a minute.
Millard, that is for the convenience of your lordship to defer to different affidavits.
We are taking up this matter, but Mr. Mishra said that something has been solved.
It has been filed. Kindly see that affidavit.
Where is that affidavit? That's filed. When it was
Kindly see that affidavit.
Is it?
And yesterday, an intervention application has been filed.
When that affidavit filed, it was not on record.
Yes, let's kindly see this document. Let's answer.
Huh? No, this is reply filed to the IE.
No, sir, kindly have a look at that.
Some affidavit against it.
Reply affidavit, your lordship
Sir,
has been
sir,
stated to file reply to the missed cases.
No, Learned Advocate General says that some additional affidavit.
No, that reply affidavit, in that reply affidavit, you have compiled everything, starting from the earlier affidavit.
Please be clear.
Ma'am.
We want that the pleading should be completed.
Ma'am.
It's not that
Yes,
in the
yes,
midst of
Pleadings are
the.
completed.
If your lordship remember.
Sir, kindly have a look at this affidavit.
Are you referring to the affidavit dated 21/7 to 2025?
Reply to
Yes,
the
yes.
IA.
This
This is a
affidavit.
reply to the IA pursuant to your lordship's last order to file an objection in opposition to the interlocutory application filed by them. Let this affidavit, your lordship is referring to this filed on 20th July 2025.
Yes.
So this affidavit, my lord, is in response to the IA, which was filed by them praying for some interlocutory order.
2913 of 2025.
That's correct, Mila.
And 2939.
And 2939 of 2025.
Right.
This is an opposition affidavit.
Okay.
So the other documents, and there is nothing new. All those documents are already, my lord, that forms a part of your lordship's record. Nothing new fact has been introduced. But on the contrary, my lord, the prayer with which they are questioning the propriety of the single judge order, that is beyond the scope of a latest patent appeal. You can't make new pleadings in a writ appeal. Or new pleas.
So let us hear Mr. Mishra then.
My lord, it's a very,
Sir,
it's a
kindly have a
very
look at this affidavit.
project
Kindly have a look at this
of
affidavit.
MCL, my lord, lots of
Just have a look at
it's
this
a 4,000 crore project.
Yes, it
They
is.
have been duly taken care of. Only, my lord, some mischief mongers, they do not want to leave the land,
Please
creating
don't.
problems.
Sir,
That's all.
I respect you, sir. Don't use those words.
No, that's correct.
Oh,
At the instance
all right,
of
I think
please,
we should be
please,
careful enough.
Please. This is copies available with you. You have given one copy.
No, sir, it is my copy I have given.
Oh, no, this, how can you see?
You want to file this,
No, sir, this is the copy I received.
the same copy.
No, not the same copy, it is something
It is
different.
something different. And
Please
then it
give it-
might not be
give it.
there. Let us see.
It is the affidavit they filed.
This report. Should I take this one? So
No, this is something.
Black 7 minute.
it is same.
Must be there in record. Madam.
Same.
Just a minute. সেটা বাহার করে পড়তাম ভুলেও যাবো। Okay. This is available with us. Please.
Yes, must be available on record. Madam. And another affidavit, application has been filed for intervention. Kindly have a look at that application. That must be there on record.
Look, the intervention application has been filed by me, Mills. I'm not pressing, if the matter is going to be disposed of today, Mills, I'm not pressing the intervention application. I appear for the contractor who's executing works at the site. To that extent, I'd file the intervention. I'm not pressing.
We are
today.
taking up it for finally.
I'm so grateful, Mills. I'm not.
All right. Yes, please proceed,
Yes.
Mr. Mishra.
For the timing, just ignore that reply affidavit and proceed.
Right.
That's the better idea.
That's right.
You are challenging the order of the land single
Single
judge
judgment.
passed in.
That writ application, Mills. That is WPC 21006.
That is annexed as annexure.
Sir, at page 38, prayer is there. Sir, that order is annexed at 121. Page 121.
121, Bhargav. Please, proceed.
If your lordship kindly turn to two paragraphs, para 9 and 10.
What was the prayer in that writ petition? Where is the copy of that writ?
Without providing the resettlement lots,
Just a minute. Let us see the prayer in that writ petition.
yes, prayer is at page 12, Malak. Page 38.
Yes.
Page 38. Malak. First prayer is reinstatement of service of the petitioner's Malak. Without attachment and imposition of any condition, in accordance with later dated 9/7/2014 of the sub-collector, issued in terms of the decision taken in the meeting dated 6/7/2014. I'll take your lordship through those dictums also.
Okay. Now we come to the order.
Second paragraph is the opposite parties shall not be directed not to take any coercive action against the petitioners till their allotted plot physically in the and look at page 89.
89. It affiliated.
That gadget. You're referring to that
Sir,
resolution. Yes.
Yes.
page 89 is the RR policy manual,
Mm.
which is applicable. There's no dispute about it. If you actually kindly have a look at page 93C,
Mm.
cut-off date for the purpose of compensation shall be the date on which notification declaring the intention to acquire the land under the relevant act or under the provisions of this policy is published.
Yeah.
Note says that for the purpose of declaring eligibility of RRN benefit, the list of displaced family will be updated on the 1st January of the year in which physical displacement is scheduled to take place, provided those families who move into the project area after determination of the cut-off date. Cut-off date is the date on which the initial 4-1 notification was made. So any family who comes thereafter will not be eligible. So this updating made till they want to take vacant position, physical position, they have to update who are the family members, whether they have been provided with now. Now, if Lordship kindly turn to clause 8, madam. Based on the list approved by the government.
Hmm.
I think Malad got it that.
Clause 8.
Based on the list approved by the government, an option of displaced family resettlement rehabilitation plan shall be prepared by the collector for resettlement and rehabilitation after due consultation of the displaced communities in the manner determined by the government. Such plan should address the specific need of the women, vulnerable groups, and indigenous communities, and the same will be placed before the RPDSC for approval. That's the committee. While preparing the plan, the following aspects should be taken into consideration. 1, site for resettlement habitats shall be selected by RPDSC in consideration of the displaced family. 2 says, no physical displacement. This is very important, Malad. No physical displacement shall be made before the completion of resettlement work as approved by RPDSC. The certificate of completion of resettlement work will be issued by the collector. Am I clear, Malad? Which I am trying to
What does
apply.
it mean by Mr. Mishra resettlement work? Suppose somebody has received the compensation and all the benefits which are available has been provided to him. What does it mean by resettlement work?
So all the benefits doesn't include this. All the benefits includes this provided the resettlement. This is in addition to, this is not separate. So they have to also provide resettlement site in addition to what they have given, like re-employment.
Suppose money is given, settlement site where that has been given. So whether that is sufficient or something more is required under that.
No, that is the only thing required, Malad. Resettlement site, and they should give money for construction of the building. If the site is provided, site must provide all the amenities, facilities for habitation. That is exactly the point here. Here, this has not been done till date.
You mean to say that this compensation amount has not been paid to you?
No. The compensation one part.
Apart from compensation.
But some compensation,
Yes. There in the policy also. It is already written.
they have not indicated what is the alternate site where you are.
They have
to set-
indicated alternative site.
Then what further?
They should provide the facilities for habitation. Resettlement,
Your grievance appears to be the certificate of completion of resettlement work is not yet issued by the collector because the work has not been completed. That's what you say. Yes.
So can you look at page 181? Their own affidavit filed flag 7. Flag 7, Malad.
Flag?
7. That document I wanted to file counter, Malad.
Just a minute.
10/6/2025, Annexure H at page 181.
Affidavit dated 21st July.
The from the reply, huh?
So 25 July से affidavit file issue.
181, we find that is annexure H.
H,
Right.
correct.
It's a letter of the collector and district magistrate on goods.
To the general manager,
General
MCL, Bhubaneswar
manager.
area, Talcher.
Okay.
But these things have already been provided.
10/6/2025.
Yeah.
But the subject is submission of present status report and completion of Bolanda RNR site for resettlement of 154 project displaced family from Hensmur Tahsil Basti. These are the present persons. I am directed to refer to the subject cited above to state that the site plan of Bolanda resettlement rehabilitation site was approved in the year 2015. As the project proponent, MCL is responsible for completing all development works at the RNR site and submitting a detailed completion report for issuance of the certificate of completion in accordance with the provisions of so it is 8.22, not 7. I read that.
A1, which was.
Right. Of the Odisha Resettlement Rehabilitation Policy 2006. The 154 project displaced family of village Hansmal are to be relocated to the Bolanda RNR site as per ORRP 2006. No physical displacement shall be effected. Kindly mark this word of the collector prior to the completion of all approved resettlement work. Accordingly, a certificate of completion must be issued by the collector following the submission and verification of the detailed completion report. Therefore, it is imperative that the provisions of ORRP 2006 are complied with in full to avoid any future legal and procedural complications. You are accordingly requested to furnish a comprehensive completion report of Bolanda RR site within 7 days to enable necessary consideration at this end for issuance of certificate of completion, which is mandatory.
8.2 is not complied. Yes, that.
Sir, the reply is there. Next
Up till
page.
10/6/2025.
Next page, kind of 19/6/2025.
19.6. Yeah.
Annexure J, Malad.
That letter.
See the reply, Malad. If you are satisfied that yes, it has been complied with, I don't have anything to say, I have to sit down. This regards status report of resettlement rehabilitation PDF from the Hensmal under Bhubaneswar area, and in this connection, we would like to submit the following facts for your kind consideration. Village Hansmal consists of 377 PDFs, out of which 223 PDFs have been opted for cash compensation in lieu of resettlement plan. That's a different matter. The balance 154, we are concerned about it, have been allotted plots at 10 decimals of land to each PDF RR Bolanda as per their own demand. No valid RR demand is pending with the. Is it an answer? No.
No valid demand is pending.
No demand is there, but they have not given a completion. What are the things that have been provided so far as the habitation is concerned? Those are the concern that was taken note of by the Honorable Chief Justice while sitting over this matter. And they say that no, you can't displace unless you complete all those resettlement proposal, all the amenities that is to be provided, like light, water, sanitation,
This
everything.
letter at the most indicate about the allotment of plots.
Allotment of plots. It doesn't say, because collector has to give certificate on completion. They have not mentioned anything. They have not replied in fact.
How many of you are there?
So 154, it has been indicated. Some actually taken the money and they have wherever place they have sold, because there is no specification of any area demarcated with the vast area given. Some of them have raised construction also, but there is no electricity, no water connection. Just construction has been made, building has been made. Few of them has been done it. But those persons who have got money compensation, they have done it. But most of them still reside in their ancestral house, which comprises their old parents, children, they themselves. The anxiety for which actually the interim application was filed, you can kind of see, look at again page 89. I'll show that here. Look at page 89.
89 of the appeal.
Read up. Hey, read up. Read up.
Yes.
Sir, proceed, sir. If you push me, I cannot go anywhere.
Government should
I just read that, but I want to explain that.
yes,
The cutoff date for the purpose of compensation shall be the date.
Where are you reading?
90 quota.
Here's 90, man. I'm sorry.
90.
Of the rate of
Of the rate of
Yes, we got it. RRR policy.
we see cutoff. Again, I have to bring your lordship notice cutoff.
Yeah.
Cutoff for the purpose of compensation shall be the date on which the notification declaring the intention to acquire land.
This is
and the
section 4
relevant act-
notification.
I just read it. Okay? They have to prepare a fresh list for the eligibility of persons are concerned who in the meantime become measured. Who are entitled to benefits. Now they have prepared a list, 84 persons who are in the meantime has become measured, entitled to the benefit. They, in lieu of the land, they wanted to give monetary compensation to them. Then the meeting was held, and they said, and we will pay you the monetary compensation. Fact remains, they issued notice saying that you take the monetary compensation, vacate within a week. But they reside with their parents, who are the beneficiaries of this 154%. Am I clear, Lord? They are the new entrants. So if they will vacate, they will demolish my house without complying the provisions of law. That is the reason why your lordship passed an interim order of status quo for a final hearing of the matter. So that is they adopted a substitute method to evict them without following the due process itself, without complying the provision of as required under law. The collector's letter is clear, my lord. It has not been done. But I'll just take your lordship to 2 orders of this honorable court, then I'll take the impugned order.
You are not eligible monetary compensation,
No, no.
like the other persons who have stated that we don't want the land at the alternate site, you give us the compensation, we'll make our own arrangements. You are not among them.
No, no,
You
no.
want that you should be provided.
Correct, correct. They are not those category of persons.
Ah.
Self-relocations.
But just now you said that
Self-relocation.
money, you are ready for money, but the time is 1 week, so therefore there is a problem. They'll give a little more time if you can take the money.
We are not those category of persons. We are different. This 154 is different. Those are the children who in the meantime have become
Major.
measured. They reside with us.
Over and above the 154.
Yes.
Oh. They were not the party before.
No.
Yes, that's the difference. Yes.
But the letter that will take possession will affect us. With the same house, they are our children, they have become measured, they are residing with us. If you take that house, my house is gone, same house.
So from out of this
From out of
150.
the right. So that is the reason why that interim application was filed, where a counter of 150 pages was filed, affidavit. But if your lordship kindly turn to
In the true sense, what is this meaning of this resettlement? As you said that it is not just the monetary compensation, it would be totally completing their house,
So,
settling.
that RR policy says that. RR policy says.
So was that.
Kindly look at that RR policy again, Lord. Page 89.
89 years.
House building assistance.
So page 97, my lord.
97.
Page 97. But it starts from page 98,
90?
96. Page 96, clause 5, top bullet. It speaks about families losing agricultural, not homestead land. Here, actually, they have already lost their agricultural land. It has been acquired.
Homestead also is okay.
And homestead also been the same.
Come to 97. 97
Yes,
and read F.
yes, F and G.
Read it.
I think you're also referring to F and G.
Yes. F.
I
House
marked
building
that
assistance. Read it.
House
Besides-
building assistance besides project authority shall construct house building assistance of 1,50,000 for construction of the resettlement site. Kindly mark the word.
Resettlement habitat. Or provide the house building.
Or provide
assistance.
house building assistance to each of the displaced families settling in resettlement habitat or opting for self-relocation. Anybody who opts that, I will have.
If it is either or, Mr. Mishra, if it is either or, how do you insist that they should construct the house, then can only will be displaced?
No construction.
Because
Not construction.
no, because the statute or the policy says that it is either or. They may construct the house for each of the displaced family, or they may provide house building assistance.
Yes.
Like they have done.
That has not been received.
Huh?
That has not been received.
No, so that is how, if they are ready to pay, if in fact you have not received, as you say, suppose the MCL agrees to pay you the house building assistance.
Correct.
So,
Resettlement site is not ready.
Immediately at this juncture, if you not say put permit. चूड़ा दही खाएगी साइड when in terms of the policy they are asking more. He is asking for employment of a person who was not even in the mother's womb when the land was acquired.
So you are,
They say,
you
just
are
a minute.
arguing it.
That is what- No,
Talk about
He
settlement.
is agreeable. He is agreeable. I have requested. We do not want to displease also the land losers. My learned senior is very kind. I had also given that proposal. Land has been given. Just a minute, please. I am in your favor. Land has been given. Many of them have already been constructed the buildings and have shifted. Those petitioners, Miller, those who are before your lordship, they say, they claim that we should be given employment because in the meantime, we have become major. Just a minute. If that is your prayer, if you
not
say
my
no,
prayer.
then let it be recorded.
No employment.
If you are not,
He doesn't want.
then let it be recorded. Just a minute.
Who are employed that have been reinstated.
No, that's correct.
No fresh employment.
That is not the issue.
That's
No.
correct. That is not the issue.
okay.
They are, third thing, the persons, those who have not constructed the houses in the resettlement site, they are being provided with the quarters by the MCL in the staff quarter. They are occupying there. I'm not making a wrong
Sir, I have not stated
I do
anything.
not, that's correct.
I'll place it.
So they are occupying the quarter here without making any payment towards the quarter charges and also occupying, staying in there villages. They came, nobody is there. It's a abandoned site. Because I called the collector and the RDC board discuss. And beloved, if we let my learned friend also accompany with me, we will go together to the site and see. There is no distress. They want to, they are asking something more. Let him sit with me. We will decide. I will call the MCL officials also. We will sit together.
Sir,
and
we
decide.
agree for
It's not
settlement.
a question that we want to dispute.
We don't want that the
That's
operation.
correct. 2007, the land has been acquired. It's a national project and coal is required for the energy, thermal energy. Those 30, 40 people are creating the disturbance. Rest of them are all vacated. All vacated.
Mr. Mishra.
We can resettle them. We are not opposed to the resettlement.
Sir, we agree first.
No, no.
We don't
Let us
want to
not-
stand in the way, but we want that.
The
should be
court has
complied with.
already observed.
Nothing more than nothing
No,
less.
that-
Why not sit together?
No,
I don't
See the- See, the Advocate General and Solicitor General is there.
And that too, my.
Their assurance, I think, is the best assurance.
Since the learned AG is himself
Yes.
is taking all this responsibility and my friend is he was also former AG, I think he understands the situation. It's a major
Let
major
a short date be fixed, let all of you sit together and I think that it can be sorted out.
Sir, as you also want it should be sorted out.
And when 154 people, you prepare a chart, who has been given what? You give that. That's there. You see that.
Everything has been.
Sir, that is what exactly in my affidavit I wanted to.
2014, without 11 years, they are not permitting the MCL to enter into this part. That is why.
I am not permitting.
Settlement means you have to sacrifice something, they have to sacrifice something, then only.
Then we cannot forcibly evict them.
No,
Sir, you-
Larger interest.
Advocate General, can we fix it next week on Friday, if you so, in the
Next
meantime?
week, Milord, we may be.
No, any date, but tell us, because of the urgency, if you want a short date, please tell us so that prior to that, you may sit together and
Can it?
please tell us.
Subject to.
Subject to your.
8th August, Natarajan? 8th August, can you come? 8th August?
Thursday. Can it be 13th August, Milord?
Yeah, there is no problem.
I am here.
Last working day.
But
12th
we
August.
request Mr. Natarajan, you and Mr. Mishra to sit together. so
Right.
that maybe he may join online or whatever he may.
That's
See, 12th will be little problematic, means we have special benches.
12.
Well, then we'll keep it at 2 o'clock. I'll come and spend some time, 2, 3.
How that can be done? There is no.
What we'll do is, we'll
this-
take the bench and sit at
Can I suggest one thing?
3 o'clock.
You not say have this special bench. But why I say every possibility there is something of bench. But your lordship should have a special bench for this.
No,
Matter. Just
no. The
Everything hard the matter, that's why.
the
It's a
problem,
5-minute job, Milord.
No, the
We'll get it resolved.
the problem is we are holding some different bench in on that.
Why, if it is 5 minutes, come at 3 o'clock today.
That's
we'll
correct.
finish.
No, he was not willing to sit. That I voluntarily, your lordship may ask, we called even the MCL top brass, and we have already decided if they are asking
put in
something, we
funding.
can financially compensate.
They are-
They are asking.
Well,
Whether it will be on- 12,
2 o'clock.
12 at 2 o'clock.
Yes.
we'll sit for some time.
Kindly, one more thing.
They should actually call me for a sitting.
Of course.
Because they are
Already
familiar.
called.
Enough.
Sir, they are mighty state
No, not
and the,
only sitting, but Acharya will arrange something.
I don't have a corporate office.
The foodie Milord, lover of food, I will also host a dinner in his honor. I'll do that.
Forget the real issue.
Sir, actually, for your lordship's information,
Learned AG is very generous host, Learned AG. So there's no issue.
sure, he has got a beautiful penthouse at his home.
One more aspect. Well, nothing happens. Now, particular affidavit, he has some reservation for filing counter. Whatever he wants to do it, let him do it
Yes,
before
yes.
that.
No, you fine.
Meanwhile,
Yes, because
Do it
on
by Monday and file it.
whatever he wants, let him place it on record.
Sir, but we are settling the matter.
No, that's right. On that, you want to argue the matter. I do not want that to be.
Settlement doesn't mean the
Sir,
condition
one
should
hand
be
settle it,
unreasonable.
another hand you file counter.
Settlement should not mean that it should be on the.
No, it's all right. All right.
Settlement means he has to sacrifice little bit, you have to
Yes,
sacrifice
yes.
little bit then.
Sir, we have already sacrificed.
Mr. S.P. Mishra and counsel appearing for the appellant submits that he has received the, what is that, reply to? That is it. Reply filed by the respondents to the IN number 2913 of 2025 and IN number 2939 of 2025. Filed by the appellants. Stop. And he intends to file what you say, what you are filing?
Objection.
Response to that.
Objection affidavit.
Objection affidavit. Okay. Objection affidavit. And it will be filed during, by Monday. By Monday, serving copy on the land and council for the appellant. During midst of the hearing, a proposal was given by the land and Administrator General that matters can be sorted out by way of amicable settlement between the parties, and the matter may be taken up on some other day, so that in the meantime, you will see to it just
We'll explore the possibility.
maybe explore all the possibility of the settlement. And
Endeavor should be made for settlement.
huh?
Endeavor should be
You
made.
explore the possibility of.
Endeavor should be made to. And on consensus of all the parties, list this matter on 12th August 2025. The matter will be taken up at 2 p.m. Mr. Natarajan is also present with Mr. Land Advocate General for the appellants. Right?
For the respondents. For the respondent.
In it,
No
yeah.
problem.
I'm sorry.
We'll correct it. We'll correct it.
Sorry.
No problem.
All right.
Deeply obliged.
Yeah.
Very interim order to continue.
Interim order for the- dated given 19/6/2025, passed in IN number so and so is extended till next date. Oh,
Grateful.
last one. Yes.
Item number 1,
Who are appearing here?
And for the, I am got instruction to appear for the opposite party number, opposite party. As because that advocate was appearing, Chen Murthy, he has already left India and shifted satellite USA. And I have got the instruction today that take instruction to appear.
What about the petitioner? What is the case, Mr.
My lord, that is the whole problem. I have nothing with me. I seek permission to.
Why don't you take all the entire?
I will by pen drive, I will take everything.
pen drive.
Kindly permit me.
Over under annexure 14. What is that 14? And annexure 8. So please come to that, you have, hey,
Ah.
whatever is, this, what he is freeing actually. Perhaps he applied for some loan and that was torn down. That is exactly what he is challenging. Come to the prayer portion, that is,
I take pardon. As reflected in the noting, that the sole petitioner has been died and he has to go for substitution. I think he has to go to list one. List.
right.
Application for substitution by deceased petitioner not filed.
Okay.
Cases I have, by that way cases are.
Okay. Now we'll dispose of. The petitioner, Sarojini Pati, is now dead. When the matter was taken off, 22/8/2015, 12/9/2015, 12/12/2015, 22/2016, 13/5/2022, 23/6/2022, 18/7/2022, 11/2022, either before the National Lok Adalat or before the permanent and continuous Lok Adalat, no one appeared for the petitioner. Even though notices were issued to the petitioner. So, the learning council for the bank submitted on 11/8/2022 that the petitioner is dead. Since no one is appearing to pursue the matter, the writ petition stand dismissed for non-prosecution. Clear nahi to death certificate पर writ किसी नहीं dismissed for non-prosecution. The recommendation for name. The counsel for the Bank of India is present.
This petition pending since 2012.
And this petition is pending since 2012. Dismissed for non-prosecution.
Item 2.
Yes, madam. You are for the?
Petitioner.
My lord, I am for the petition.
Yeah. Which for the opposite
My
party?
lord, I am appearing for the bank.
Okay, what is the prayer in this writ petition?
So the fourth feature, the amount 5 lakhs, to the tune of 5 lakhs.
The forfeiture towards the auction
Auction bid.
conducted by the bank, and the petitioner did not deposit the remaining amount. So it is a statutory forfeiture. So against that, the petitioner has filed, but it is not maintainable here because DRT is, there is Supreme Court judgment is there. It is maintainable for the DRT. That is Agarwal Tracom Private Limited and PNB.
Yeah.
There is also another matter which was tagged with this matter.
Yes.
My lord, I pray that matter be tagged with this matter and may be listed.
No, it is for actually for referral of the matter to the special mediation drive. But it can be sorted out here, matter is well and good, then otherwise you are to approach the DRT.
No, my lord, it is not maintainable before DRT. That is why my only prayer before your lordship, let these two matters come together next week. Then it can be heard, otherwise it can be sent to mediation.
So mediation, bank has instruction not for mediation because statutory forfeiture. So bank cannot go for a mediation because it is not like that they are auction purchaser. It is not like the borrower and the bank.
My lord,
So
I am
because
the auction purchaser.
So the auction purchaser has failed to pay. So I will satisfy your lordship. 3 Supreme Court judgments are there.
You are challenging Annexure
My lord,
8. Annexure 8, page 89.
Yes, ma'am.
Just read it. Annexure 8.
Yes, my lord. We have received your letter number date nil regarding refund of the deposits made by you. We advise you to go through the auction list, other 5 terms and conditions of auction, which indicates that in case the successful bidder fails to deposit 25% of bid amount immediately on the sale being knocked down in his favor, and the balance within 15 days, the entire deposit made by the bidder shall be forfeited by the authorized officer without any notice. Please read para number 3 of the letter number, wherein it was clearly mentioned that the amount deposited by you would be forfeited if you fail to pay the rest amount by 30/11/2011. Hence, there is no scope for giving an opportunity for hearing against forfeiture of that.
Yes.
What do you say?
It's a contract condition.
My lord,
Auction is also a contract. Where's the condition?
this matter, actually, I was on the impression, my lord, this matter will be referred to mediation. For
No. Now the bank is not agreeable for mediation. So why will unnecessarily send there and it will be getting delayed? Perhaps it is, and it's a 2012 matter.
Yes, my lord. My lord, may I pray? It may listed on Monday so that I'll come prepared and I'll place all the judgments. And
What is the other matter? How it is
The
connected?
other matter is, my lord, in the similar matter, decree has been issued by recovery officer attached the same property.
No, is
So
it
they have
connected?
challenge also here. So matter should you go to there and
The party is same or something?
yes,
the
my
party
lord,
says.
same. But here the difficulty is that, my lord, only
Just a minute.
Both the matter Monday.
Yes, my lord.
Mr. Dilip Kumar Maharana, London Council, appearing for the State Bank of India, submitted that there is no question of mediation in this case. The bank is not agreeable for the mediation. Stop. The London Council for the petitioner submits that another connected matter, that is WPC number. Give the number, madam.
607 of 25.
3607
Up to 2020.
3607 of 2012.
25.
25 is sub judice before this court, and the matter may be tagged to the said writ petition and be listed in the next week. Land Council for the bank has no objection. Put up this matter with WPC number 3607
3607
of
2025.
2025. Let it be then on 30th of July 2025.
Yes. Great.
Item 3.
This is a matter which
it is an appeal against the order passed by the Odisha Administrative Tribunal. So in view of the judgment of L. Chandra Kumar, this has to be decided by a division bench of the Assembly.
No, it's question is it has come whether it can be referred to the mediation or
My
not.
lord,
Yeah.
statutorily it cannot be because
What is the relief sought for?
my lord, it's a, here the order of the tribunal is under challenge.
Hmm.
So the in view of judgment of L. Chandra Kumar, so this has to be-
That part is gone.
Then we are not.
so it has
What is the relief sought for?
relief sought for, my lord. Here what has happened, my lord?
Why you have filed the OA?
Yes, my lord.
Tell us.
A person who continues to be a Group D employee was forcibly retired at the age of 58 by misconstruing him to be a Group C employee. So that here the issue is whether the post in against which the post of computer attendant against which the petitioner was petitioner was promoted way back in 1990 can be treated as a Group C employee for the purpose of retiring him at the age of 58.
So it's not a matter which can be referred to the
Yes.
mediation.
So that is what I say.
Yes, my senior has mentioned that, but initially he was appointed as a peon. Thereafter, he is promoted to the post of the computer attendant. The computer attendant is the Group C post because of as per the pay scale, it's commonly Group C post.
No, we are not hearing on merit. It's for a limited purpose that whether there is anything in the matter which is not in the mediation center or not. Otherwise, we'll fix it.
Yes,
for
ma'am. You'll
regular-
also fix a date. That is by your prayer.
The pleadings are complete.
Yes, ma'am. Pleadings are
All
complete.
right. And the land and council for both the parties submit that the matter cannot be sorted out in the mediation by way of mediation, and it may be decided the merit in view of the submission. There is this matter for a review in the week commencing from 4th August 2025 for final disposal. Yes.
Item 4.
Item number 4, in this case, they have removed me usually without giving any opportunity of being had, which was challenged before the Honorable from CAT. And CAT dismissed the case on the ground that even if we accept that, then it is the state government letter which is obstacle to that, which is challenged before this Honorable Court. That
It cannot be settled in the Loko Adalat. Yes, mediation. कौन कौचंदी?
Ames is the opposite party who has removed from service.
Is there any chance of settlement? See, 2014 you have been removed, huh? No. Yes. 2014. Now what is your age?
My lord, my age is
Today.
I am still can be on government service.
What is your
39 was in the year 14.
14.
49.
14.
50
Who is appearing for Ames?
Mr.
Union Opinion. Yes, you are appearing for Ames.
My lord, actually, the conducting counsel is not present today because of his some personal difficulty.
No. Are you appearing for the Ames or Ames as a separate panel?
No, now we are appearing for Ames.
So that's all. We just want.
No, now it's clarified, my lord. We are appearing for Ames.
Think of settling the dispute in coming Lok Adalat or mediation something.
It is to be referred to the mediator for settlement, but whether it is such a matter which can be.
My lord, let me give some few days. I ask the law officer and he will clarify what is the position. Then
So we are taking off next week. You just take instruction.
Yes, my lord. Yes, next week.
It's for limited thing. If it cannot be, then it will be placed for regular hearing. That's a different matter. But only it has come for that.
Yes, but
Party Land and Council appearing for the M's submitted that the matter may be taken off next week so that he can take necessary instruction if the matter can be sorted out in the mediation put up this matter. The date they give you let it be on 30th also. No.
Yes.
30th of July 2020. Yes.
Right.
Item 5.
I'm appearing on behalf of Mr. Arun Patnagar. We have no instructions in this matter. We tried to get in touch with the.
What is the prayer in this writ petition?
Challenging
Challenging. Challenging the order of the London Administrative Tribunal.
Yes, not interim order it was.
Interim order.
Yes.
3/10/2016.
The OA might have been disposed
OA
of
might
by
have
now.
come here and disposed of.
Is there any
All
mistake?
these OAs are transferred to this court. The old matters. Order has been stated that any appointment motion subject to the intact. OPSC has recommended the name to the government, keeping in view interim order. There is no need to pass any further order and grant any appointment portion. It's become infructuous. Land Council appearing for the petitioner submits that he has no instruction in the matter. Land Council for the state is present. The writ petition is disposed of, is dismissed from non-prosecution purpose. So this one and all these connected matters, huh? Yes, next.
I'm grateful.
Item 6.
Yes, state, it is your petition. What is the prayer in this petition? OA number 825, you are challenging the order dated 13/9/2017. What is that order?
But the another petition, that is the 1902/17. That case was this Honorable Court disposed the matter and remanded back. So I play let it come next week, you take the instruction regarding.
Who is appearing for Mr. Otto? You are appearing?
Yes, my dear Lordship, see the London Tribunal's order starts from page 13.
1-3.
Right.
1-3 because.
In fact, the case of the private respondent covered here, private opposite party, being challenged by the state is already covered by 3 other persons whose case is upheld up to Honorable Supreme Court. That is what London Tribunal has taken note of. If Lordship sees, kindly see.
His prayer was to
absorb Narinda Women's College. Let's see page 16.
16.
By the same governing body, this person and 3 other persons were appointed, and there was dispute as to governing body, and ultimately the government took over the institution. And these 3 persons, let's see page 16. Case of Bimbadhar and let's see
Bimbadhar
Thurapati, Ajodhya Narayan Mahanti, Pavani Behera, and Badrinarayan Patra. But these people were appointed by the same governing body by which I was also appointed. The same governing body. And governing body had those two secretary and principal is valid, upheld by this Honorable Court. Now, all these persons were similarly placed, same date of appointment. Now, inquiry was conducted. Inquiry was challenged here before this Honorable Court. And this Honorable Court has upheld the saying that acquittance roll, their names finds place. But the inquiry did not consider that. That is how the inquiry had negatived our case. But this Honorable Court considered the entire thing, not set aside the whole thing, and now they are set at risk. They have got all the benefits. But so far as the petitioner is concerned, based on same set of inquiry is same set. The tribunal referring to that has passed this order. Lakshmi kindly see page 17. Referring to all the previous proceedings has passed this order. Page 17, madam.
Please place that. Which line was?
Should I place it?
Which line?
Page 17, only 2 pages I'll place. Without giving a detailed account of the case. Para 5. Considering the rival claim and submission, the only question that requires determination is whether the applicant has an employment in the college as on 1/4/90. Without giving a detailed account of the case, suffice to say that because of mismanagement and disturbance in the college, the government issued ordinance dated 27/6/91 taking over management of the college, and the said ordinance was subsequently converted to Act called Narinda Women's College Education So-and-so Act. As per Section 7, the said Act, all the teaching and non-teaching employees of the employment of the colleges as on 1/4/90 shall be deemed to have been absorbed in the government services as employees of the college in their respective posts with effect from the date of its transfer. Teaching and non-teaching staff whose name found place in the audit report and notice dated so-and-so of the administrator alone were treated as government servants.
the name of the applicant and some others did not find place in the audit report as well as the notice of the administrator. As indicated, being agreed by the applicant approached OA number so and so, which was disposed of with common order dated 22/97 for the tribunal directed to constitute a high-level committee to inquire into the matter and take appropriate steps on the basis of report of the committee. The report of the committee in respect of applicant is as follows. He was appointed as a typist on ad hoc basis for 89 days by the order dated 29/12/88. Subsequently, an appointment making permanent has been issued by Sri B.K. Mani on 1/5/99. The only document in support of his service in the college with letter dated 15/11/90 signed by V.V. Vidyarthi. No other evidence is produced in support of his service in college. The applicant challenged the report as it is not based on material on record. It may be noted that prior to taking over of the college by the government, as there was dispute between two rival groups of the governing body, matter was carried to the Honorable High Court. Honorable Court, by their order dated 30/10/90, has held that B.K. Mania, who was the secretary of the college, V.V. Vidyarthi, who was principal of the college, will continue as secretary and principal of the college until further orders. The case of the applicant is that orders have been issued by Principal V.V. Vidyarthi before and after cut-off date, engaging in different work of the college, which clearly shows that applicant was in service of the college as on Ekchari 90. Continuance of the applicant in the employment of the college is evident from letter of engagement dated 30/88, 89 days basis, and dated 1/5/99 on permanent basis, and letter dated 15/11/90 of the college signed by V.V. Vidyarthi. Report of the committee has been strongly refuted that there is no document to show his presence during the period from 90 to 90, which is completely wrong and incorrect. On the facts of those cases, finding of the committee that applicant was not in service is not acceptable. Council submitted that OA 3283/98 acquittance roll from November 89 to December 89, January 90 to June 90 have been filed, from which it appears that applicant was in employment of the college as an Ekchari 90. The tribunal in the said case clearly observed that had the acquittance roll was not genuine, respondents would have produced the genuine documents to dispel the claim of the applicant. As in case referred to above, and under similar circumstances, the tribunal has already observed Abani Behera, Ajodha Narayana, Bimbadhar Senapati in employment from Ekchari 90, and there is no reason to discard those documents and take a different view in respect of applicant who is similarly placed. More so, no material has been produced denying the claim of applicant that he was not in employment of the college on Ekchari 90. The report of the committee on the basis of which the claim of the applicant was rejected is not supported by any material or document, hence rejection of the claim of the applicant without any basis and liable to be passed. In view of the above discussion.
And no back wages, only notionally it was given.
And
these are finding of fact.
Yes, my lord. I place it. That's why there are three persons getting the same benefit. So I say let from next week take the instruction.
What instruction?
Generally situated persons have already got the relief, and why he will be deprived?
There are detailed fact finding by the tribunal.
Because they are not
in the read court, why should we
report in the committee? And
sorry, Lefon, this petition has been filed by the state of Orissa, challenging the order dated 13/9/2017 passed by Orissa Administrative Tribunal, Bhubaneswar Bench, Bhubaneswar, in OA number 825 of 2017, oblique 752C of 1998. Stop. It appears that the opposite party, number one, Ashwini Kumar Sahoo, approves the as on 1st April 1990, as per the provision under section 7 of the Orissa Act, 24 of 1991, and to take him back in service and extend all service, financial service and financial benefit. It is the case of the opposite party, number one, that he was appointed as typist in the college, that जो नॉलेज देवी तब college college here आपको. As per the order dated 29/12/1988 on 89 days basis, and thereafter he was appointed on permanent basis, on a consolidated salary of rupees 800 for month, as per the order dated 1/5/1989. There was some mismanagement and disturbance in the college, and ultimately the college was taken over by the government, and by ordinance, an act named the Nalini Devi Women's College of Education, bracket, taking over management, Odisha Act 24 of 1991, came into being, and after the and as per the provision of section 7 of the said act, the teaching and the non-teaching employees of in the employment of the college as on 1st April 1990 shall be deemed to have been observed by the government service. To implement the provision, the audit of the account of the college, the employees whose names have been placed in the audit report as well as in the notice dated 11/7/91 of the administrator were treated as government servant. However, since the name of the petitioner, opposite party number 1 and some other employees did not find place in the audit report, they were not being treated as the employees of the college. Stop. The opposite party approached the Odisha Administrative Tribunal way number 1699 of 1991 along with others similarly situated persons, and all the original applications were heard together and disposed of by a common order dated 20/2/1997, and the Land Tribunal directed the petitioners to constitute a high-level committee to inquire into the matter and to take a follow-up action on the basis of the report of the said committee. Accordingly, the committee was constituted, and during inquiry, the opposite party number 1 appeared before the committee and submitted documents and other material to show that he was an employee of the college as on 1/4/1990. However, the committee submitted its report on 7/11/1997 to the effect that there was no credible materials to show that the opposite party number 1 was in employment in the college as on 1/4/1990. On receipt of the report of the committee, the government rejected the claim of the opposite party number 1, and being aggrieved by the action of the government rejecting his claim, the opposite party number 1 again approached the tribunal for a direction to treat him as an employee of the college as on 1/4/1990 in OA number 825 of 2017 /OA number 752C of 1998. Stop. After issuance of notice in the matter, the petitioners filed their counter affidavit, and stand was taken that the opposite party number 1 was not an employee of the college, which was taken over by the government on 1/4/1990. Rather, he was appointed as a typist on ad hoc basis for a period of 89 days and subsequently on permanent basis by the secretary, and no other document was available that he was an employee of the college as in this said date. The Land Tribunal, considering that the cases of Bimbadhar Senapati, Ayodhya Narayan Mahanti, and Pavani Behera, and Badri Narayan Patro stand in the similar footing like the petitioner, has been pleased to hold as follows. Quote paragraph number 5 and 5. After going through the averments taken in the writ petition and the impugned order, and hearing the learned counsel for the respective parties, we find that the learned tribunal has rightly hold that on the basis of the relevant documents, the finding of the committee, that the opposite party number 1 was not in service is not acceptable. And since similarly situated persons have got the employment in the college as on 1/4/1990, and there was no reason to discard the documents of the petitioner, sorry, opposite party number 1, and to take a different view. And as such, denying the claim of the opposite party number 1 on the ground that he was not in employment of the college as on 1/4/1990 is not sustainable in the eye of law. We don't find any illegality or perversity in the impugned order. Therefore, the writ petition being devoid of merit stands dismissed. They're just coming within 2 minutes.
Item 7.
Kindly taken next to it.
No, it's only for
Only
that
that
whether that
prayer,
it can be.
initial prayer in the tribunal was that for anti-regularization and for cessation of pay and pension. That was a negative and that order is challenged. The government is ready. Here is also instruction, if the government will be ready, it may be referred to mediation center.
କଣ କହୁଛନ୍ତି?
Mediation center.
Let go regularization, you can
What
give.
is anti-regularization?
Whatever.
On consensus of both the parties, the matter is referred to the mediation center.
The national form. National mediation for
Mediation for the nation. Mediation for the nation. The deputy with is trying system way to submit the mediation report. Result of it. Try on the board jaha koruchandi then the time would have been maybe 3 months kete dekin de debe ha buchi debe onno court kete din deuchandi ha. Yes.
Item 8.
Item 8, the petition was filed challenging the order passed by the Honorable Central Administrative Tribunal in quashing the order of termination of the employment. The pleadings are complete, it may be listed for hearing.
No, what was the employment? What was he working?
She was working in Postal Department
Yes.
at Dhaka Sebab.
Yes.
Dhaka Sebab.
Gramin tax service.
Group B.
That is that outside the regular post of the department, they are extra department employees, man. And they are called GTS, man, Gramin tax service, man. They have been
Audio book mediation
Post-
level.
Postman.
In this case, my lord.
Actually mediation
Hearing
jibo ki
before-
nahi?
Yes, my lord, to that, my lord.
Otherwise
Because hearing, my lord, earlier bench, they actually agreed to comply with the order. You also kindly have glance to the order sheet dated 7/3/2024.
7/3?
7/3/2024, my lord. Then 22 February 2024
1 minute.
and 2nd February 2024. They actually submitted before this honorable court.
Compliance of the order.
Comply the order, my lord. And they took time several occasions for compliance.
Let us come to 2/2/24. What is 2/2?
My lord, without complying, my lord, now after 5 years, my lord, they filed a IA for stay of that order passed by the 11th Tribunal.
The opposite party has already given employment in terms of the order passed by the Central Administrative Tribunal. So that is the instruction the Union of India sought for.
Because there is the Central Administrative Tribunal passed when? The order 19. 3/1/2019. There was no stay. Meanwhile, have you given effect to that?
Well, stay was allotted in the in IA number 4696 of 2019, but order dated 8/3/2019. But subsequently, it is the identity contracting council failed to.
You are appearing for Union of India.
My lord.
Question is that you are to take instruction as per the order dated 2/2/24, whether he has already been given employment or not. That's all. As per the order of this month. What is your instruction?
My lord, I have sought for instructions.
No. See, come to the order dated 24/11/2022. 24/11/22 says the interim order passed on 21/11/2019.
My lord.
But the same has not been extended with effect from 10/12/2019.
My lord, for
So therefore, there was no interim order as such.
my lord, for that purpose, I filed IA number 6386 on 7/5/2024 for extension of the stay that was allowed in the previous IA 4696 order dated 21/11/2019. My lord. For the extension of that interim
20
order.
what? 2019.
My lord.
That has been not extended.
That is not extended.
My lord, for that
You are given a specific direction by this court on 2/2/2024 that to obtain instruction whether you have given employment or not, because there is no stay order. Stay order has already lapsed. That you are showing that There was no extension to that. It is specifically mentioned after 10/2/2019, there is no stay order.
As per the instructions, he was not appointed as per the order of the Governor Cat, but I will obtain further instructions for. I will make sure whether it is completed or not. Here the matter may.
It can be referred to the mediation center.
Tell the mediator.
The Land Council for the Union of India, Mr. So-and-so submits that he is yet to obtain instruction as per order dated 2/2/2024, whether the opposite party, Kalpana Naik, has been given employment the order dated 2/2/2024 and the subsequent orders, we feel it proper to refer the matter to the mediation center.
Till now, interim protection may be granted.
No.
Because in the contempt notice has been issued and the date is fixed.
It should be issued. It should be issued. Yes. Next.
Item 9.
Now, my lord, the order of a punishment of a compulsory retirement is under challenge. And the London Tribunal dismissed the case, though the specific ground was that no authority, he had no authority who had initiated proceeding and the punishment as the order.
Can it be Mr. who is appearing for the
Central government?
Mr. Pari is not there.
Have you now attained the age of superannuation? Yes. Then that's why it will be possible. What will you do now? Now that if the order will go, then he will be entitled for the benefits as because the authority is the question of authority.
No, you submit that this matter cannot be settled in the mediation, so this matter in due course for them.
Also pleading is also are complete timely.
Since the pleadings are complete, it's this matter, August 2nd is present. Okay. For final disposal.
Item 10.
My lord, in this case, my lord, Union of India is present. Item 9.
Item 9, we have noted out.
Congratulations.
Item 10.
Yes, item 10.
I am for the opposite party, Punjab National Bank, Lordship.
What is the prayer of the petitioner here?
They have challenged the 13-4 notice, Lordship.
Yeah.
13-4.
Now, that was in much earlier, 7/7/2021. Like 13-4 notice has been challenged. Dated so alternate cases remedy available, disposed of the judgment Land Council so it appears for the Punjab National Bank, right? Give the name so that it can be.
Item 11.
The criminal appeal matter. Case matter, the challenging the order of conviction imprisonment for life.
302. Not had been admitted. On it, hard admit for the trial court report. Interim applications for bail and stay relaxation of fine to be considered after receipt of the trial court report. In the meantime, the deposition copies be supplied to the London Council for the trial court report. It appears that the trial court report has already been received in CRLA number 667 of 2025. Just a minute. CRLA 6 next work on 667 admission. In which matter?
Already admitted, my guess.
Which one?
All the matter. 667.
All right. You have not filed the.
Already admitted, my lord.
My lord, we have instructions to
Our LCR also received.
It's all right. That has been admitted. No need to further. Yes.
We have instructions to appear in all the matters.
File your Wakalatnama. It's not necessary to it. Which is 7444 of 20.
The admitted.
Admit है नहीं अच्छा it according to same order like the previous one that is 722 है ना so 722 मझीटा किसी परिवेनी 667 रे किसी दरकार नहीं already admit है ये जी अब एटा 744 टा admit करी जहाँ ताजर लिखिए एटा लिखिए अच्छा what about this 758 Mr. Patnaik admit है नहीं पर admit करी same order कर दे all right next
Item 12.
My lord, here the appellants have been convicted on section 376D and also 376-2N and sentenced to imprisonment for life and also to pay fine of rupees 30,000.
All right, admit for the trial court report. You have only filed a stay relation of
My lord, my son. I have already filed today, but it has not been come up, so may I permitted to for a bail application.
अच्छा लेकिन पहले
So, my lord,
ये किसी फॉर्म दूनी पहले लेकिन Mr. Patnaik Land Council appearing for the appellant submits then an interim application for bail has been filed today.
Today I was told to
It will be filed today. अच्छा then you file the memo being filed it will be listed for the orders and trial court report be called for deposition copy to be supplied in usual order whatever. Yes, next.
My lord.
Item 13.
The appellant was convicted for life and to pay fine of rupees 10,000.
Offense.
302 men.
302.
Yes, sir.
Admit same order for the trial court. Yes. So.
Item 14.
Lots of pieces to appeal against statute of the
What is the offense for you? The other side face trial?
Lots of under section 302.
Against the acquittal.
Why the order was passed? Is it a case based on direct evidence or circumstantial evidence?
There is no direct evidence on it.
Then what are the circumstances?
Lots of there is some severe witnesses who have stated that on the confession of the accused, there is recovery of acts.
Recovery of the weapon.
Yes,
that one axe was recovered.
Yes, sir.
So if there is nothing, merely because one axe was recovered at the instance of the accused, can it be sufficient to convict the accused? So that ground he has taken that chain must be complete and the London trial court found that the chain is not complete.
Yes,
and this circumstance alone is not sufficient.
Yes, sir.
So that is how the acquittal order is passed. What is the wrong in it?
No, sir. I am for the OP number 2, Your Lord. So we have acquitted, Your Lord.
Now that who is for the petitioner? Or that means appellant.
Yes, sir. Appellant.
You have not filed any power. Your name is not there. Are you appearing in this 807?
Yes, Your Lord. So A Pradhan.
You are for Babu Shetty.
Babu Shetty may appear kurjanta?
Sorry, Your Lordship, we are for the appellant Suresh Chandra Pradhan.
You first decide whether you are for accused or for a complaint.
Suresh Pradhan hochi appellant je ki thila tala court re informant tenu sie challenge karchi order of acquittal tenu apano eporjanto bi jani nadi ka pai appear kurchanti.
Sorry, Your Lordship, we are for the
Very busy lawyer, not able to get time.
This appeal has been filed by the informant Suresh Chandra Pradhan, challenging the judgment and order dated 6/5/2025 passed by the London Additional Session Judge Talche in CTS number, case number 26 of 2020 in acquitting the respondent number 2, Babu Sethi, of the charge under section 302/201 of the Indian Penal Code. Stop. The prosecution case in short is that the appellant presented the written report before Khamar police station, before the inspector in charge of Khamar police station, stating therein that he, along with his deceased elder brother Ramesh Chandra Pradhan and his family members, were staying in their house, which is situated in Upper Sahi of the village. And the deceased was unmarried, and after taking dinner, he used to go to the old house situated at Tala Sahi of the village for sleeping. There was some land dispute between the family of the informant with one Bismaya Parid. And on 23/7/2020 at about 7 a.m., the appellant got the information that the deceased was lying in bleeding condition in the old house. Immediately, he rushed to the spot, found the deceased has sustained bleeding injuries at 3 to 4 places on his head, and immediately the appellant shifted him to CSC Khamar in an ambulance for treatment, and during course of treatment, the deceased succumbed to the injury. The appellant suspected that due to previous enmity with the family of Isma Parida, they might have murdered the deceased. On the basis of such a written report presented by the appellant, Hamar PS case number 128, dated 23/7/2020, was registered under section 302 of the by 30 Indian Penal Code. During course of investigation, the investigating officer held inquest over the dead body, sent the dead body for post-mortem examination, and found prima facie case against the respondent number 2, and on completion of investigation submitted charge sheet against him. Stop. In order to prove its case, the prosecution examined 22 witnesses, and the Learning Trial Court considered the material oral evidence as well as the documental evidence on record, and came to hold that it is a case based on circumstantial evidence. And the only circumstance that is available against the respondent number 2 is the recovery of what was that? Counter recovery, one asked on the basis of the statement made by the respondent number 2 under section 27 of the Evidence Act. The relevant para 13 22. The Learning Council, the Learning Trial Court came to hold that basing on this piece of evidence, it cannot be said that the chain of circumstance is so complete so that it can unerringly point towards the guilt of the accused. Though it was held that the deceased made a homicidal death, but in absence of circumstantial evidence, the learning and also absence of any cogent motive on the part of the respondent number 2 committing the offense, the Learning Trial Court found the respondent number 2 not guilty of the offenses charged. Accordingly, acquitted the respondent number 2 of all the charges. Court paragraph number 13 and 14. The Learning Council for the appellants fairly submitted that except the leading to discovery of the acts, there is no other material against the respondent number 2. unless it is established that the seizure of the acts has got any link with the commission of the crime, a recovery is not sufficient to convict an accused under section 302 and 201 of the Indian Penal Code. In view of the settled position of law as laid down in the case of Sarad Vrichand Sarda, reported in 84 Supreme Court set of court wherein it has been held as so and so, we find that the land and trial court is quite justified in passing the informed judgment and order of acquittal. There is no perversity. Accordingly, the criminal appeal being merit stands dismissed. Yes.
Item 15.
The appellant before your lordship has been convicted under 376 Roman 1, 302, 201 of the Indian Penal Code, related with section 6 of the POCSO Act, and undergo RI for a.
All right, we are admitting it, and you serve an extra copy because POCSO Act is there, notice has to go.
Yes.
You are going to admit, call for the trial court record, extra copy of the appeal memo, along with the interim applications be served on the land council for the state, which will be sent to the informant in Jajpur, which will be sent to the IIC of Jajpur Road Police Station for its service on the informant in Jajpur Road PS case number 3 dated 4/1/2016, and it will be intimated to the informant that if informant of informant lady, if she is interested to engage counsel of her own to oppose the application bail, she can do the same. If she needs legal aid assistance, then Wakalatnama can be obtained by the IIC and it will be sent to the High Court Legal Aid Committee so that a lawyer can be appointed from the panel to appear for the informant to oppose the application for bail. Deposition copies be supplied to the Land and Council.
It is there in the appeal.
All right.
Everything had given in
Okay.
there. There's an interim application. I will also serve an extra copy.
What is the interim application?
Well, an interim application to release the petitioner, because his father has to undergo.
Acha, the Land and Council for the state shall obtain instruction on the interim application for bail, that is IA number 1930 of 2025, which has been filed on the ground of ailment of the father of the appellant, basically relying on some medical document. Medical document,
Yes.
all right. The authenticity of the medical document shall be ascertained by the land for the state. Yes, next.
Item 16.
Item 16, lordship, here my friend is appearing as a debitor. So I have to serve a copy of the writ petition.
Mr. Mahapatra, Land Council supplied the copy of the writ petition to Ms. Mahapatra, who is appearing for the caviter. And
Ms. Mahapatra appearing with the writ.
Ms. Mahapatra, info you have already sub.
No, I'm just serving, lordship. But here one gets, lordship, there are 20 opposite parties. But Ms. Mahapatra is filed for the petition for only 6 persons. So if she receives notice for all the persons, it's all because in the land trial tribunal.
What is your instruction, madam?
She was appearing.
You are only for opposite party number 1.
1105297. For these persons, she has filed the KB. But it's a fact in the land tribunal also she was appearing for the all the.
You serve a copy. Let him go through the petition. We'll take up this matter for fresh admission next week. Yes.
That's my record. I have served the copy.
All right. Copy has been served is this matter on 30th of July 2020 for fresh admission. Yes.
Item 17.
I may please your lordship. I want virtual member.
Some of the respondents got some of the opposite party got is Mahapatra. Yes, Mr.
Yes, madam.
Mr.
Yes, madam. But I have challenged the order of this London Central Administrative Tribunal denying the consequential benefits. That's the kindly see the order of the tribunal. At page 97 is the relevant page, Mal.
Mr. Mishra, we have asked you to file the. You have filed.
Yes, madam. I have brought it through a memo. I have given it.
Okay. So what was the prayer of the petitioner before the London Tribunal?
Let's see, kindly turn to page 22 of the tribunal brief, madam.
22 relief sought for.
Yes, madam.
Okay.
Was the order of order dated such and such under the annex?
What are those orders, Mr. Mishra?
These are compulsory retirement order.
Okay, sorry.
And direct the respondent to reinstate the application in service with effect on such as direct the respondent to grant all the consequences and by financial benefit in view of reinstatement in service.
What was their stand? What is the counter? Have you filed the counter affidavit?
Yes, madam, I have filed the counter affidavit.
That is annexure?
That is no, madam, annexure. I have brought it through. I have given it to memo.
No, we asked you to file it. You have only filed the original application.
No, I have given the counter also, madam.
Counter also filed?
Yes.
Achha.
As per my instruction, I have given also counter.
Counter time. Counter ta ebe file करछन ना आगुरु annex करथिले
ने मेमोरी सर देथिली
ए जो एटा गोटे brief facts of the case लेखाई जी सेई गोटा counter affidavit ना तो
yes perhaps my advocate record is there madam, he can tell better.
That is right. Okay. Well, what is the stand taken?
Stand taken is compulsory retirement is right, it is sustainable, therefore it is court should not interfere. We are review committee, we have examined, it is not a punishment, it is under public interest. Under FR 56, madam.
How the London Tribunal dealt with it? In which paragraph?
Tribunal has quashed the order. I have no grievance. I have only grievance that consequential benefits, madam.
Please come to paragraph, page number 97, Mr. Mishra.
Para 29.
Yes, madam.
Please read it.
Page number 70.
97, Ronnie page 97.
I'm obliged.
And paragraph is 29.
Yes. On examination of facts and in hand with reference to the provision of rules of law laid down in case of such and such, we find sufficient force on the submission of the applicant that there has been miscarriage justice caused to the applicant in decision-making process of the matter requiring judicial interference by the tribunal. Accordingly, the impugned order such and such are quashed and consequently the respondent direct to reinstate the applicant with notional fixation. That is my objection, madam.
So some relief has been granted in your favor?
Yes, ma'am. Only prayer is that because in all cases, let's say, can you turn to page 47? Let's say, can you turn to page 47?
Okay.
Let's say, look, my lord, serial, all are the compulsory retired, my lord. All persons are compulsory retired in one letter. Let's say, look at serial number 3 and 4 and 5. They approach the different tribunal, my lord. Let's say, can you turn to page 100, my lord.
100?
Yes.
Yeah.
They approach the different court because of jurisdiction. They approach the New Delhi, 100, my lord. Then 101 is Jabalpur. They have allowed the consequential benefits and the financial benefits.
Yes,
then consequently, I have given a judgment, my lord. I have given a judgment also.
Yes, what judgment?
Of course, single judgment, persuasive value, my lord.
Yes, notice has been issued.
No notice has not been issued.
All right. The writ petition has been filed.
My lord, in this case, my lord, we will file them.
Okay.
Seriously, they're testing. Yes, Mr. Paddy. Mr. Paddy, are you contesting this matter?
They are similarly situated persons have given consequential benefit in other central administrative tribunal, New Delhi. This man has been deprived of it. He has been the order has been quashed, but so far as that monetary aspect is concerned, he has been deprived of. So they are similarly situated because by
It
one
is listed
order,
of
all
first
of
time.
them.
Let me give some time. Will take instructions.
Look, this writ petition has been filed by the petitioner Gupta Chandra Bidika, challenging the order dated 3/12.
But sound is not too well.
We have sound authority. It's functioning. You able to hear us?
I am able to hear.
ଆପଣଙ୍କର କଣ ଟିକେ ଖରାପ ହେଇଥିବ ଦେଖନ୍ତୁ।
ହଁ ତାହେଲେ ଏଠି କଣ ପ୍ରୋବ୍ଲେମ ବୋଧେ ହଉଛି ଆଜ୍ଞା
ମେକାନିକ କୁ ଡାକି ସଜାଡୁନାହାନ୍ତି ଆଉ କୋର୍ଟ କୁ କହୁଛନ୍ତି yes order dated 3/12/2024 passed in ON number so and so by the London Central Administrative Tribunal Cuttack with regard to notional fixation of petitioner's pay without any back wages. Mr. Mishra, and senior advocate, submitted while referring to the office order number 26/12/2022 issued by the joint GM personnel, wherein 6 numbers of persons, including the petitioner ନା ଦେହରେ ଅଛି ତି ନା କଣ right were directed to be retired from service with immediate effect. And they were relieved and their services were struck off from the strength of BSNL with effect from 26/12/2022. Mr. Mishra argued that the persons named in serial number 4 and 5 of that order, namely Ashish Pathak and Chandragupta Bidika, challenged the said order before the Central Administrative Tribunal of New Delhi or what? Who challenge kale?
One is New Delhi, one is Jabalpur, madam.
New Delhi and Jabalpur, and the orders have been passed not only in allowing the prayer, in quashing the aforesaid letter dated 26/12/2022, but also se joda dekhouthile kahi seta kete number page re
100, madam.
101.
101.
But granting all consequential service benefit in accordance with the rule between the period from 26/12/2022 till joining in the duty. It is the contention of the Land Council for the petitioner that since petitioner stands in the similar footing like so and so he should not have been deprived of the same by the London Central Administrative Tribunal. Stop. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. The Land Council for the Mr. Paril and Deputy Solicitor General accept notice on behalf of opposite parties number 1. ସମସ୍ତଙ୍କ ପାଇଁ ତ ରହିବେ ବୋଧେ ସମସ୍ତଙ୍କ ପାଇଁ ରହିବେ ତ ମିଷ୍ଟର ପାରି 7 ଜଣ ଅଛନ୍ତି BSNL ଆପଣ appear କରୁଛନ୍ତି
Malad 1347.
ଆଚ୍ଛା ଆଉ BSNL ପାଇଁ ଆପଣ ନାହାନ୍ତି
Mr. Prakash.
ଆଚ୍ଛା ଆଚ୍ଛା 1 3
4 7
1 3 and 4 and 7 ହେଲା let extra copies of the writ petition be served on the Land Council for the Union of India so far as 2 4 and 6 are concerned. Thank you. Panel council अछंती ना भारतीय संचार Nigam Limited, BSNL. Huh? Okay. Let the copy of the writ petition be served on Mr. Prakash Chandra Bari, who used to appear for BSNL. Put of this matter after 4 weeks, counter affidavit, if any, be filed in the meantime. Yes.
May I pardon, my lord? May I pardon? My lord, Ashish Kumar Pathak and
Suresh Kumar.
Suresh
Kumar Pathak and Suresh
instead of Chandragupta
Ashish Kumar Pathak and Suresh Kumar.
My lord.
And Suresh Kumar.
Serial number ठीक है तो?
4 and 6.
4 और 6 से जो पेज नंबर 47 ने 4 और 5 कोई तो ले
पिटिशनर में
5
और पिटिशनर
4 and 6 लगे
My lord.
है ना?
Suresh Kumar, Ashish Pathak.
Ashish Pathak and Suresh Kumar, है ना? Yes.
Okay.
Item 18.
Mr. Mahanti. Yeah.
Here in the writ petition, the present petitioner is challenging the inaction on the part of the opposite party number 1 in delivering the vacant position of the land which I have purchased through the auction purchased from the opposite party number 1. The opposite party number 1 has issued a sale certificate against me, while annexure 1. They have filed application before the CJM Cuttack, while annexure 2 to deliver the vacant position of land to me. In the meantime, what they have done, while order dated 11/9/2024, they have withdrawn that application. And till then, they have not delivered the vacant position of land to me.
I'm appealing for the bank.
What is your instruction?
Let them serve a copy, I'll take instruction.
Please give the names. You will file wakalatnama for the Punjab National Bank.
Yes.
Submit that he has instruction to appear so and so. The case of the petitioner is that he was the auction purchaser of the property and sale certificate was issued in his favor. The bank bracket legs opposite party number 1 filed miscase oblique petition number petition 118 of 2024 before London Chief Judicial Magistrate Cuttack against the opposite party number 2, Messrs. Rishita Agro Industries, under section 14 of the Surface Act for taking over possession of the secured asset. With a further prayer to direct the Deputy Commissioner Police Cuttack to provide assistance oblique aid to take the said property into custody and hand over the same to the authorized officer of the bank. The Land Council submits that the bank subsequently withdrew that petition.
Yes.
And even though the petitioner is the
page 55 days.
Page, which should be evident from the order dated 11/9/2024 of the London CJM from Assistant Session Judge Cuttack. It is the contention of the Land Council for the petitioner that the petitioner, being the auction purchaser and in whose favor sale certificate has been issued, has been deprived of getting possession vacant possession of the purchased property.
No, the liberty to file a better application, but better application has not been filed.
Acha.
That's what.
So and so,
So the liberty to.
with liberty to file better application, but the better application has not been filed. Stop. Issue notice on the question of admission indicating therein that the matter shall be, he wants to take no instructions. The London Council for the so and so submits that he has instruction to appear for the opposite party number 1 Punjab National Bank. Let a copy of the petition be served on the London Council for the London Council and matter be placed on next week. Ranantu, paisa patra negala sabu negala file kala 14 application withdraw kar dele.
Are you sure that the application is not filed?
No, my lord, application is
Please this matter on 1st August 2025. Yes.
okay.
Item 19.
Your Lordship.
Yeah.
Lordship, due to some emergency, Mr. Deacon Kumar Sarna, senior advocate, is not here. So I kindly take chance.
My lordship, on behalf of Sri Tuna sir, for the OP number 1 Bank, Union Bank of India, let a copy of the writ petition be submitted.
Have you filed your wakalatnama?
My lordship, my secret standing officer.
Standing counsel for the Union Bank of India. But you have to file some your wakalatnama. Na lekhi diyon to kahar pata kuchum. Submits that so and so has instruction to appear for the Union Bank of India, Bhubaneswar. Let a copy of the writ petition be served on the counsel for the bank. Will file wakalatnama. A mention is made on behalf of Mr. Bigyan Kumar Sarmal and senior advocate for adjournment. This matter in the week commencing from 4th of August 2025. Yes.
Item 20.
And take over Monday.
Sir, you have challenged an e-auction notice. You have alternate remedy.
When here comes, same order will be passed.
We give liberty.
So we are giving you liberty to approach the DRT. It can. We are not expressing any opinion on the because of so many decisions of this one. Lekon, the writ petitioner, Hiren Kumar Sahu, has filed this writ petition challenging the e-auction sale notice under Annexure 1, which is dated 8/7/2025, issued by the opposite parties stop in view of so and so decision. Since alternative remedy is available to the petitioner, we are not inclined to entertain this writ petition. Liberty is granted to the petitioner to seek for approval, alternative remedy. Yes, disposed of. Yes.
Lordship, my appearance may be not.
Diyantu now. So and so appear. Apano na lekhin diyantu. Yes, next.
Item 21.
21, let's do please. Here, business being indicated by the prepared writ application, the informed order is annexed 1 page 17. Let's see. Here, what happened? Let's see. Admittedly, the department has filed a writ application challenging order passed by the tribunal, and had annexed 3 page 27. That writ application has been dismissed, being withdrawn. And let's kindly come to page 27, where the honorable judges have disposed the writ application. One of the honorable judges, for which a review petition is filed by the department, is still pending, as because it could not have been listed. During pending of the review application, a content petition has been filed with the Land Tribunal by the present opposite party, and Land Tribunal by annexed 1 has been pleased to direct the present petition number 3 and 4 to be present personally, and so also in failure of that, and to comply the order passed in the OA number 172 of 2017. In failure of that, they have to deposit 10,000 rupees each to the opposite party. That is the order passed in the annexed 1 lots. Here, the four petitions are indicated by the situation, and the review application is pending as because this could not be listed for the formation of a bench because honorable court.
What is review about it? What is this order? Annexure 27. Let's see.
Yes, in fact,
What is review about this order? Let's see.
I have had the copy.
There is an order passed by the tribunal. The court says that you comply the order. What is review about it?
In fact,
How will you maintain a review against
You
that?
file the writ petition,
yes,
you withdraw that writ petition, and obviously once you withdraw this, the court directed that you comply the order.
that's it. That's
So you did not comply. You filed a contempt petition. Now, what kind of review petition will be entertained against a order which you have withdrawn yourself?
I'm conscious of that point.
Then forget about the review part now. Next you tell us.
In fact, let's say
Review will be eventually it will be dismissed.
in fact, let's say the review application was filed on the ground that while disposing that writ application, honorable court has relied upon a judgment which was subsequently also agreed by the
Court judgment কোটা
again.
আমাদের কিছু লেখাই নেই এই অর্ডারটারে
Again, এই অর্ডারে কিছু লেখা
কোনটা
এই অর্ডারে কিছু লেখা
ଆପଣ ଏଇ ଅର୍ଡର ଏଗେନଷ୍ଟ ରିଭ୍ୟୁ ପିଟିସନ ଫାଇଲ କରିଛନ୍ତି ପରା
ଆଜ୍ଞା
ଆଜିରେ କଣ ରିଭ୍ୟୁ ହବ ଆପଣ ଲେଖିଲେ ଅର୍ଡରରେ ଲେଖା ହେଇଛି the so-and-so Learning Council appearing central government stated that the petitioner may be permitted to withdraw the writ petition in view of the above the writ petition stands dismissed as withdrawn. There would a review petition କଣ file
review petition the file is stating that there were some grounds of challenge, but that will not
Withdraw kahin
properly
করতে?
demonstrated.
See, let us be very clear about it. There was a order dated 21/10/2022 passed by the tribunal. You had a right to challenge, you had challenged by way of writ petition. You have withdrawn it. Therefore, the court says that since you have withdrawn the writ petition, comply the order. As simple as that. What is review about it? What review you can file?
Review is already been filed, but
No, no.
yet to be
It's all right that but
Unless
that
they're
remains that
harassing
no order has been passed and contempt petition filed and it was you are asked to comply the order. So why again you have come up?
The reason is that that's it because
So do you mean to say that even an order goes against you, you will not comply the tribunal's order?
we will
Then
we will comply. The
You
only
answer
thing is
whether
we have to-
21/10/2022 order of the tribunal attained finality or not. It has attained finality.
Yes, in view of
In view of the withdrawn of the writ petition.
of course,
If it has attained finality, you have to comply.
that's true.
As simple as that.
That's true. That's true. But
Don't bring review and all this thing.
only we are trying to exert a forum because the review we have made out some good grounds in the review, subject satisfying the honorable court also. So as because the review is pending and in the meantime this order is passed, so
This petition has been filed by the Union of India. You see,
You are Union of India. Don't ask people
what are
like
this
this.
type of litigations? What is this challenging the order of the London Central Administrative Tribunal Cuttack Bench in CP number 7 of 2025, which arises out of 172, way number 172 of 2017. It appears that the said application was filed by the opposite party Saroj Kant Malik with a prayer for a direction to the petitioners to regularize the service of the of his service for the leave vacancy period from 8/10/1998 to 8/9/2011 and to pay all benefits as admissible to the to him. Stop. The London Tribunal, after hearing the parties, by order dated 21/10/2022, passed the following order for the relevant portion, that is paragraph number 9. Stop. It appears that the Union of India challenged the said order before this court in WPC number 18611 of 2023. But when the matter was taken up on 15/5/2024, the London Central Government Council made a submission before the court seeking permission to withdraw petition. Accordingly, the writ petition was dismissed as withdrawn, and this court passed the order directing the petitioner, Union of India, to comply the order of the London Central Administrative Tribunal dated 21/10/2022, passed in OA number 172 of 2017 as expeditiously as possible, preferably within a period of 3 months from the date of receipt of the certified copy of the order. It further appears that since the order was not complied with, the opposite party, Malik, filed the contempt petition before the London Central Administrative Tribunal,
CP number 7.
CP number 7 of 2015 bracket record.
25.
25.
CP 7 of 2025. And while order dated 26/6/2025, the London Tribunal has been pleased to pass the direct the petitioners 4 weeks time to comply the order and file full compliance report, filling which the petitioners are to appear personally before the tribunal on 1/8/2025, and further directed that if the order is not complied with by the next date, a cost of rupees 10,000 shall be imposed on the petitioners. The London Council appearing for the Union of India, Mr. Mahapatra, submits that against the order of this court dated 15/5/2024, in which the writ petition has been dismissed as withdrawn, a review petition is pending, and therefore the London Tribunal was not justified in passing the impugned order dated 26/6/2025. We are not able to accept the contention raised by Mr. Mahapatra, since no interim order has been passed in the review petition. Moreover, it is
dated 21/10/2022.
and moreover, the order dated 20/10/2022 has attended finality after withdrawal of the writ petition by the London Central London Council appearing for the Union of India. Therefore, we find no infirmity or illegality in the impugned order. Accordingly, the writ petition being devoid of merit stands dismissed. Yes, next.
Pardon, madam. Item 34 and 26 have made a mention with regard to 34, my lords. There is an interim idea for interim bail. Then his younger sister's marriage has been fixed to 1st of August.
What instruction?
Yes, my lord.
In this case, I am appearing for the informant.
This application has been filed
in
the ground of younger sister's marriage, which according to the petitioner is fixed on 1/8/25, and he has annexed wedding invitation card, and we asked the London Council for the state to obtain instruction.
Correct.
So, but
before going to consider, I am handing over to a copy of FIR where the Pinky is one of the accused who are married to another person. Whether the same Pinky is not, that has to be verified by.
Let us see the report of the London.
First report be seen, thereafter I am handing over
The marriage is
Pinky
alias Meera Acharya.
Just a minute. Mr. State Council,
My
you
lord.
have produced the report of the IIC Dharakot Police Station.
My lord.
So you have mentioned that the marriage of the younger sister of the appellant, Pinky alias Meera Acharya, is scheduled to be solemnized on 1/8/2025 with Nabin Acharya,
My lord.
son of Maleswar Acharya at Satyanarayan Temple, Barampur.
My lord.
So this is correct. Yes, Mr. Naik, what do you say?
FIR kindly see because this if this Pinky, she has also earlier married to another person, affair is there, my lord, and her family members are there in the accused.
No, whether he.
Whether that Pinky is said.
Verified it.
Yes, my
Verified
friend has to verify.
Already verified. Already verified.
That has not been verified.
No, Pinky Mira Church.
Yes, this is the Pinky father is same. There he see there, my lord, kindly see the affair. I have submitted.
Affair Pinky Achari.
Yes.
Here Pinky Achari.
No. Others, everything is same.
Pinky, eh?
Yes.
Accused number?
Accused, my lord.
Pinky is
Accused column में kindly see.
Pinky Achari.
Yes.
Husband.
Where this Balaji also there, serial number 2.
But in this case, the criminal appeal, Pinky is not accused.
I'm not saying that, but perhaps my friend is not understood. Pinky Achari had married to another person. Marriage is continuing. The mother of the husband.
What you want to say is Pinky Achari, whose marriage is now scheduled,
yes,
has already married earlier.
Yes, that is continuing.
That is there. Later you go and attend the party.
Whether same Pinky is here or not.
Completely
Valid marriage or invalid marriage, you are not examining.
We are just, brother is asking to go for some time to attend the marriage of the.
My next.
Might have been divorce also, who knows?
No, that I am saying, well, he is on bail, he has committed this offense and in custody for more than 1 year.
Who has?
This petitioner applicant, my lord. He is in column number 2. And at the time of pronouncement of judgment, he was absconded.
Yes,
Judgment was deferred.
Mr. Yeah.
That is there.
That is completely irrelevant, Manoj, because present.
You know that in one matter, in this marriage matter, we granted bail to a particular man, just attending the marriage of the sister. And actually the sister on the family member, they were suppressing that one of family members is already been convicted 302 and is in. So they have suppressed it. The moment this man went to attend the marriage, that marriage collapsed. So we do not know that whether the family members are interested that this man should come out and attend the marriage or not. So you assume that may be also another thing.
Yes.
But is it a correct statement that this man was granted bail for some time and he has committed offense?
In this case, even though the IAC I would date I will obtain instruction that apart, my lord. There is
one, my lord, taken place 10, 12.
अच्छा केबे मैरिज अछि एक अछि समझ आपण आनंद Monday put up this matter. The land and council for the sorry the land council for the state has
he's creating some doubt. Let us clarify
that report is not there, but over phone IAC intimated that on the date of pronouncement of the judgment the accused trying to abscond.
No,
if I may clarify for a moment.
Just a minute, you clarify on that day. The marriage of the younger sister of the petitioner is scheduled to be solemnized on 1/8/2025 with one Naveen Acharya. Mr. S.K. Nayak, Land Council, appearing for the informant, filed the first information report in High Court PS case number 606 dated 28/8/2023 and submitted that the petitioner was granted bail during the trial, and while on bail he committed the offences under section 294, 304, 379, 5065, 34, for which the aforesaid case was instituted. Stop. Let the Land and Council for the state obtain specific instruction as to whether earlier the petitioner has flouted the terms and condition of any bail order or not, Secondly, whether the family members, his family members are interested for the release of the petitioner on bail or not. The instructions are
Member of the
put up this matter
Room
on
side,
28 July 2025. Yes.
my lord, on 29.
29, the other bench will be there.
30.
Okay, 30th of July 2025. This is item number
34.
South Zero.
Minor.
Rest of the
Minor item.
That industries matter result that is 36.
Today there is no time after lunch. The Cuttack bench.
He was only praying, can it come on Monday?
Minor.
So there is a small matter. It can be disposed of within 5 minutes.
October Asiwa. Roy Joe.
You will only take 5 seconds.
Just include it. We'll see that.
Minor. Item number 32 is small matter. There were modification.
What modification?
9/7/2025.
Just a minute. Co-order ta kitna number item?
Item 32.
32.
Fine. 111/2024.
Sahe?
Case number जैसे रिले 111/2024.
32.
Item number 30.
All modification ta kaun tu?
My lord, 9/7/2025 order dated. Mana ka typical mistake.
Koda kohuna di.
Interim bail for a period of 4 months from the last order, my lord.
Yes.
Portion of the order.
And the date of release and the petitioner shall be surrender before the law and trial court immediately on a spare of the 4 week. 4 months last 4 weeks.
Oh, acha.
4 weeks.
All right. Let me. This is an application for modification of the order. Hard Miss Pina Pani Tripathi. Land Council submits that the petitioner was granted interim bail for a
Interim. 4 months.
for a interim bail for a period of 4 months by order dated 9/7/2025.
4 weeks.
Please hold on.
Yes. 9/7/2025 in IN number 73 of 2025. And though in second line of page number 3, it is mentioned as for a period of 4 months, but in the 5th line, it has been mentioned as 4 weeks, and the same may be corrected.
IN number modification 162/25.
Oh. You are seeing order what is this?
In view of the Land Council for the state has no objection. In view of such submission, in the 5th line of page number 3 of the order dated 9/7/2025, passed in IN number 73 of 2025, 4 weeks shall be read as 4 months. The rest part of the order shall remain unaltered. Urgent certified copy of the order be granted. Ella?